is Social Security acceptable reasons for not getting treatment or being fully compliant with medical care that might be applicable in an ERISA disability claim? Now, Social Security rulings suggest that there might be credible explanations as to why an applicant isn't getting medical treatment or isn't compliant with that medical treatment. Number one is daily activities are structured to minimize symptoms. Two, the symptoms may not be as severe enough to prompt an applicant to seek ongoing medical treatment or can be relieved with over-the-counter medication. Number three, the applicant might not take the prescription medication because the side effects are less tolerable, if you will, than the actual symptoms. Number four, the applicant may be unable to afford treatment and may not have access to free or low-cost medical services. Number five, the applicant may have been advised that there's no further effective treatment that can be offered or that would benefit them. Number six, the treatment might be contrary to the teachings or tenets of a person's religion. Number seven, the applicant may have undergone surgery without successful results and is reluctant to undergo repeat surgery. Number eight, the treatment might be like open heart surgery, pretty extreme, and might be risky surgery. Number nine, the treatment involves amputation. Number 10, that the prescribed treatment is something like cataract surgery, where if you lose the sight in that eye, you just have one eye. And if you have a bad eye and now you're having surgery on the other eye, you could be blind. So in the context of a Social Security case, if the judge or the claims examiner finds that any of these are applicable, that could be a credible explanation as to why you might not get medical care. And if the judge or the claims examiner finds that this is incredible, obviously the claim is going to be denied. There's obviously a question of compliance. So how does this all play out in the context of an ERISA disability carrier? So I will tell you that they don't take the same approach that Social Security does. Disability insurance claims are month to month, and therefore the disability carrier or plan expects that you're going to be getting medical care with a frequency and level consistent with your claimed disability. So let's compare and contrast that laundry list that I just went through. The daily activities structured to minimize symptoms. Now, if you can structure your symptoms, or your daily activities to minimize your symptoms, they're going to say that you could do that with work activities. Number two, the symptoms may not be severe enough to prompt you to seek ongoing medical treatment, or it's relieved with over-the-counter medication. Now, I will tell you that no treatment is a violation of the terms of a policy or plan, and you're expected to get that treatment. But if you're getting over-the-counter medication, the disability carrier plan is going to say, well, there isn't any reason why you can't work because that's just minimal treatment. Number three, the applicant may not take the prescription medication because of side effects, and the side effects are worse than the actual disease or the symptoms. Now, the disability carrier is going to look to see if there was other medication that you could take that would have little or no side effects that would allow you to work. So they're not necessarily going to buy that argument. Number four, the applicant may be unable to afford the treatment or not have access to free or low-cost medical care. Carrier or plan says, too bad, so sad. The policy requires that you get regular medical treatment. So you're going to get it or the claim is going to be denied. Number five, the applicant may have been advised that there's no further effective treatment that can be prescribed that would benefit them. Now, disability carriers are always going to take the position that there's some form of treatment that you should be getting, even if it doesn't necessarily benefit you, as stupid as that may sound. Number six, the treatment may be contrary to the teachings or tenets of an individual religion. Notwithstanding your religions, some disability carriers or plans may say you have the obligation to get the treatment, and that there's an alternative to that treatment that does not violate your religious tenets or beliefs. Obviously, that needs to be well documented in your medical records. The next argument is that you may have undergone surgery with unsuccessful results, and you're reluctant to repeat additional surgeries. And most carriers will accept that argument or position, but they're going to say that you still should be getting conservative care in the form of therapy, medications, or injections. They expect that you're going to get treatment. Number eight, the treatment might be significant, as I've said, like the open heart surgery, or it might even be a risky surgery. The disability carriers are a bit more sympathetic with that one, but they still want you to exhaust all conservative treatment before they'll concede that you shouldn't be required to undergo that risky surgery. So they want to see medical visits, injections, the use of pain medication, perhaps physical therapy. Number 10, the treatment like cataract surgery for one eye with an impairment in the other eye, which could result in blindness. They get that, the courts get that, and generally they're going to sort of give you a pass on that one. But they also want to see that you've been through the whole modalities of treatment, for example, with a visual impairment. Same way with any surgeries like a heart transplant or other cardiac surgeries. They want to see that you've exhausted all of the types of therapies that could be used. So you can see that disability carriers can take a completely different approach than the Social Security, and that could be the basis of a claims denial. If you have any questions about your rights to benefits, call me today at 727-894-3188 for a complimentary consultation. I look forward to helping you get the benefits you deserve, regardless of where you live in the United States. 727-894-3188.